Thank you so much for that very generous and lovely and warm invitation. It's really lovely to be here with you, Valerie. I just salute all you have done, and we were talking just before about the visit you had made to Cox's Bazar. And so you, as I know, that what happened in Myanmar in 2016 and 2017 and 2018 is almost beyond description. I've just come from spending 3 weeks at the International Court of Justice arguing that case, in which the witness testimony was so acutely painful that the interpreters and others needed support after hearing the testimony in order to be able to proceed. It's on that level of horror. So I am going to talk about aspects of that case. I'm going to talk tonight about accountability and impunity and veer quite widely. But I do want to begin by just expressing my greatest personal appreciation for everything you stand for, Alf. I'm here when I received the invitation to give this lecture. It's one of those very few invitations that you don't even hesitate for a nanosecond. The only hesitation I have to say is coming south of the river, because I'm a Camden boy. Sorry. But once I'd got over that, which took about 0.1 seconds, it's such a thrill to be here, because you embody a set of values on so many issues, not least recently the well-being of child refugees, which is an issue that's very dear to me at a personal level. You're sitting next to my mum, who was a child refugee, and that means that issue I'm very proud of is very personal to me and to my family. But also right now, my wife is very involved with an organization called Baobab, which provides psychological support for child refugees. And in an atmosphere in which the mere word refugee just generates such vitriol and unpleasantness, I'm so proud to stand here in honor of you and all the work you have done to change the dynamic on that debate. Thank you for what you have done. There are also other very curious coincidences in life. As those of you who read my books know, I love coincidences. And you came to London back in 1939, to Britain, thanks to the work of the extraordinary Nicholas Winton. What you didn't know, but what I shared with you this evening, is that all of the work that he organized, he did from number 24 Willow Road in NW3, which is about 6 doors down from where I live. And so that kind of personal connection is one that I really love. You came of age, Alf, in 1945, and I know from your speeches you've given and writings you've given that the general election that year was of singular importance for you, as it was for so many people. It was an incredible year because it was the year that modern international law came alive. The 1945 moment, many of us refer to it as, defined the world in which we all essentially live today. And it's under challenge, and that's what I'm going to talk about this evening. Because 80 years on, it is said that we live in a moment of transition and very grave challenge. Global warming, pandemics, war, economic crises, mass migration, and new technologies have given rise to a time of transition and uncertainties. And this gives rise also to a great number of questions about the writ of international law today. And some are now saying that we live in a world without rules, or even a post-rules world. Others take a different view. And in this lecture, I'm going to talk about international law, human rights, and impunity. And this is also, of course, a moment today, without getting into any detail, in which issues of accountability for wrongdoings of the past are a very significant issue. And I would just like here also to express my thanks to some of the volunteers who are here this evening, one of whom we met, who works with the Clement James Centre, which provides assistance to victims of the terrible fire at Grenfell. And thank you, all of the volunteers who have helped put this evening together. Impunity is at the heart of what I'm going to talk about, and there is a degree of impunity in relation to Grenfell, and there is a degree of impunity in relation to the stories that are front-page news in our country today. And I'm going to begin with a single issue to illustrate how international rules and values move across time and place. The issue relates to the immunity that can be claimed by a former head of state in relation to official conduct. It's an issue I've been very engaged with over many years. Professionally, you could see that it's at the beating heart of the trilogy of books that began in Lviv in the years after the First World War, led to Nuremberg and Rome in the 1940s, and then to London in the late 1990s, and Punta Arenas even more recently. In 1919, in the aftermath of the First World War, the victorious powers agreed that Germany's former ruler, Kaiser Wilhelm II, who had fled to the Netherlands, should be arraigned before an international tribunal on a charge of warmongering, a supreme offense against international morality and the sanctity of treaties, as stated in the Treaty of Versailles. This was historic. It was the first time in human history that the immunity of a former head of state was extinguished because of the gravity of the offense he was said to have engaged in, an international crime. In the end, no tribunal was established, prosecutorial enthusiasm waned, and the Dutch government made it clear that Wilhelm would not be extradited to any place, and he never was put on trial. In August 1941, President Roosevelt and Prime Minister Churchill agreed a document called the Atlantic Charter, one page, a set of principles that committed the two countries to a new order premised on multilateral rules to prohibit the use of force, promote economic liberalization, and protect the rights of individuals and groups. That too was a historic moment. And that document, the Atlantic Charter, informed the creation of the United Nations in 1945, and then the Nuremberg Statute 3 months later, signed here in London at Westminster Hall. A US Supreme Court judge, Robert Jackson, served as chief prosecutor of the Nuremberg Tribunal, and he also led the drafting of the tribunal's governing statute. He wrote a letter to President Harry Truman in June 1945 to set out his thinking. Immunity, he wrote to the president, is an obsolete doctrine. It is a relic of the divine right of kings from another country and another place. And he wrote, it is inconsistent with the position we take towards our own officials in the United States. It's a telling comment because Jackson seems to take it for granted that the US Constitution provides no immunity for a former American president. Jackson worried that giving immunity to a former president or to former Nazi leaders would give rise, as he put it in his words, to the paradox that legal responsibility should be the least where power is the greatest. And as Jackson saw it, an American president would have no immunity once he or she left office. In August 1945, 4 negotiating states, including the United Kingdom, adopted the Statute of the International Military Tribunal for Nuremberg. And Article 7 provides, I'll quote it, the official position of defendants, whether as heads of state or responsible officials in government departments, shall not be considered as freeing them from responsibility or mitigating punishment. In other words, no one at Nuremberg could claim immunity in respect of the tribunal's jurisdiction. Official conduct following orders would not be a defense. And that principle likewise meant no immunity for Karl Dönitz, Hitler's successor as Reich head of state, or Hans Frank, who was Germany's head of state in Nazi-occupied Poland. Both were tried, both were convicted, and Hans Frank, along with 9 others, was hanged for his crimes. The principle of no immunity before international criminal courts or tribunals has subsequently been very widely applied. In the 1990s, the United States led the world in creating tribunals for crimes committed, and I know, Valerie, you've been very involved in this, in the former Yugoslavia and in Rwanda. And that was the reason why former President Slobodan Milosevic of Serbia could be indicted, arrested, and tried. But of course, he died before the verdict came out. When the International Criminal Court was negotiated in 1998, it removed all immunities for international crimes over which it would have jurisdiction, not only for former heads of state or government, like former President Rodrigo Duterte of the Philippines, who just a few months ago was indicted, secretly arrested, and transferred to The Hague for the murder of 41 narco traffickers, which the court's judges said is a crime against humanity. But immunity was also removed for serving heads of state or heads of government. And the International Criminal Court has issued arrest warrants for President Omar al-Bashir of Sudan, whilst he was president, current President Vladimir Putin of Russia, and current Prime Minister Benjamin Netanyahu of Israel. And like the United States, none of these countries is a member of the International Criminal Court, and they reject the court's jurisdiction and argue that a serving head of state is entitled to immunity under general international law. The ICC says otherwise, but there will be an issue to address on those points. By the late 1990s, the issue that remained was the question of immunities before national courts. These are all international tribunals that I'm talking about. And it was alleged that a former head of state or government had, in official conduct, committed an international crime. Could they be indicted before a national court? Can a former national leader ever be arrested by another country and judged by its courts for crimes, such as torture or genocide, committed elsewhere while in office? That's a very real question right now with the arrest, the abduction and arrest of President or not President, there's a debate, Maduro of Venezuela. These are very real issues right now. But the answer to the question as to whether such a person can be indicted in general is yes, or at least it has been. In recent decades, the vector of legal evolution has pulled international jurisprudence and national jurisprudence away from the idea of a blanket immunity for certain people. To my mind, as an international lawyer who's been deeply involved in human rights cases, this is the right direction. The idea that criminal law is applicable to any person, even a king or a president, before a national court is of course not new. In 1649, in this country, King Charles I was put on trial for a wicked design to erect and uphold in himself an unlimited and tyrannical power to rule according to his will and to overthrow your rights and liberties. He was convicted and he paid with his head. In 1764, remarkably, the Italian lawyer Cesare de Beccaria offered a rationale for the idea that a criminal law should extend to all rulers and why criminal sanctions should apply globally for certain grave crimes. And I quote his words from 1764, "Nothing changes. The certainty that there is no place on earth where crimes will go unpunished may be an effective means of preventing them." That said, for centuries the rule was clear. A foreign head of state could never be subject to the jurisdiction of the courts of another country, either while in office or afterwards, if it related to official conduct. The immunity from prosecution was absolute. The US Constitution, which came into force in 1789, makes mention of immunity for some, but not the US president, either while in office or afterwards. In 1812, the Supreme Court of the United States recognized that a serving foreign head of state had absolute immunity while present on American soil. It said nothing in that decision about immunity from criminal prosecution for the US president. Indeed, the US Supreme Court has said nothing on the subject until July 2024, which I'm going to come to. It took nearly another century and a half after the Supreme Court's 1812 ruling for the international legal regime to make a significant turn, and that happened at Nuremberg. It's why Nuremberg is so important. And following that ruling, most of the world's countries have also signed international agreements on genocide, on torture, obliging countries to prosecute or extradite to another country wishing to prosecute any person alleged to have committed such crimes. And these international agreements either explicitly exclude the right to immunity for any person, like the 1948 Genocide Convention, or they pass in silence on the matter. That's the 1984 Convention Against Torture. By the late 1990s, one big element of the legal situation had become pretty clear. A former head of state has no immunity when it comes to international crimes before international tribunals. What was unclear was what would happen if a former head of state accused of an international crime found himself or herself before a national tribunal in a country other than their own. Enter Augusto Pinochet. Augusto Pinochet was the commander-in-chief of Chile's armed forces when he seized power in a coup d'etat on September the 11th, 1973. As the head of a military junta and then as president, he led a regime that suspended democratic rule and due process, detained tens of thousands of people, and instituted a widespread regime of kidnapping, torture, and disappearance, including by the use of helicopters from which victims were dropped into the ocean. At least 3,200 people were murdered in Chile during the Pinochet years, and thousands, if not tens of thousands, were tortured. To this day, the whereabouts of more than 1,300 people remains unaccounted for. Pinochet was well aware of the potential dangers he faced under national criminal laws, including those of the US in September 1976. His regime murdered Orlando Letelier, who had been Chile's defense minister under Salvador Allende. He was killed in a car explosion near DuPont Circle in the heart of Washington, D.C. Within a year of the assassination, Pinochet had promulgated a sweeping amnesty law to prevent Chile's courts from sitting in judgment on the crimes of his regime. When Pinochet left office in 1990, he was appointed senator for life, a position that gave him further protection, absolute immunity under Chilean law. 8 years on, believing himself to be immune from legal challenge, he traveled abroad. There had been no case in Chile between 1973 and 1998 in relation to any of the crimes committed by the Pinochet regime. He thought he was safe coming to London. He had tea with Margaret Thatcher. He dined at the River Cafe. He went to Hatchard's to buy books about Napoleon. He watched Star Wars movies. He gave an interview to the wonderful journalist John Lee Anderson of The New Yorker, telling him, "I want a gesture of reconciliation." "What do you mean?" Anderson asked him. "I want an end to the lawsuits." Although he was protected by his own amnesty law and immunities, at least 9 criminal lawsuits had been suggested against him. And the mere talk of lawsuits against him drove him crazy. "An end to the lawsuits," he told Anderson, and he repeated the words, according to Anderson, banging frequently on the table as he did so. "They always go back to the same thing. They always go back to the same thing," he said to Anderson. A few days later, Pinochet checked into the London clinic in Marylebone for a minor operation on his back, as the New Yorker published the interview by Anderson. And a photograph in that issue of the New Yorker portrayed Pinochet as serene, powerful, untouchable, a civilian in a pale blue tie that matched his eyes. On the evening of October the 16th, 1998, while recovering from a minor operation on his back, he was arrested by 4 officers from Scotland Yard and a marvelous interpreter called Jean Pateras, who you can read about in my book, 38 Laundry Street. They were acting on a warrant issued by a judge in Madrid who sought his extradition to Spain, charging him with genocide and torture. Actually, the case had started in 1996 after the killing in Chile of Carmelo Soria, a UN official, and other Spanish nationals. I'd never heard of Carmelo Soria, but in writing my book, I came to know the prosecutor, Carlos Castrosana, who had initiated that case in 1996. I learned the name, and when I shared it with my mother-in-law, who is also a refugee and of Spanish origin from the Civil War, she said, "Ah, yes, I had forgotten cousin Carmelo." These things are very personal in ways you can't imagine. Pinochet was arrested. And the arrest was unprecedented. It had never happened before in human history. The very first time ever that a former head of state of one country is detained in another on charges of international crimes. The interpreter, Jean Pateras, was the one who delivered to him the words of the moment of his arrest. And when I finally tracked her down, it was with great relish that she said with me what it meant to say to him, "Senator Pinochet, I am informing you that you are under arrest by these officers from Scotland Yard." I asked Jean what his reaction was. She looked at me and said, "Oh, it was marvelous." He looked at me and said, "I know the fucker who's behind this." It was correct. Juan Garces, a lawyer who had been an assistant to Salvador Allende and was in the Moneda Palace on September the 11th, 1973, and had promised to Allende he would never, ever give up on doing justice in relation to what had happened. Pinochet's legal team argued that the former president had absolute immunity before the English courts. They maintained that the acts alleged came under the rubric of official conduct, and so Pinochet could not be detained or extradited. The court proceedings, in which I would be involved as counsel for Human Rights Watch, an intervener in the case, were very convoluted. I think it's fair to say I dodged a bullet in the case. I'm a barrister. I'm a strong believer in the cab rank principle. I was originally approached by Senator Pinochet's lawyers. I was in Paris at the time at my grandfather's funeral, and I told my chambers I would be back in touch the next day. There was an intervening event when I told my wife, to be honest, with some degree of excitement, that I was going to be involved in the Pinochet case, which was the most important international criminal proceedings since Nuremberg for Pinochet. "Will you do it?" she said. "Well, cab rank principle." She said, "I'm American. I think the cab rank principles are nonsense, as you know. Will you do it?" I said, "Well, cab rank principle." She said, fine. "Do it if you want to do it, but I'll divorce you tomorrow." I didn't do it. I found a way out. The great thing about the barrister's rules is there's lots of exceptions, and I ended up acting for Human Rights Watch against Augusto Pinochet. I went crawling back to my wife. She gave me the thumbs up. A panel of 3 judges at first instance, led by the fantastic Tom Bingham, ruled that Pinochet had absolute immunity under English law because he was a former head of state and all the acts in question were official conduct. I mean, it's not a critique of the Bingham judgment. They heard the case very, very quickly. In just a couple of days, it was not fully argued. On Tom Bingham's view, there was no exception to international crimes, and his ruling says the Nuremberg precedent is irrelevant because that was an international court, not a national court. And Bingham and his 2 colleagues could not find a single case anywhere in the world in which a national court ruled that a former head of state had no immunity for crimes of this kind. Spain appealed, or the Crown on behalf of Spain, appealed the decision to the House of Lords, the highest court in the United Kingdom, today the Supreme Court. And eventually, in March 1999, an earlier ruling of November 1998 was set aside due to the role of a former student of University College, Oxford, Lord Hoffman. The Law Lords ruled in March 1999, 7 judges, by a majority of 6-1, that Pinochet had lost his immunity under international law. Why? The operation of the 1984 Convention Against Torture, which entered into force between Britain, Chile, and Spain in October 1988. That treaty, the majority ruled, obliged parties to prosecute or extradite torturers. And the necessary implication of that was that they had a right and a duty to do so. Lord Hope of Craighead, who was one of the judges in the majority, concluded that any pre-existing right to immunity under international law could not survive torture on such a scale as to amount to an international crime. The ruling, which was premised on a world of rules and laws, had huge, huge significance. It set a precedent that could in time be followed by national courts in other countries. And so henceforth, any former head of state who engaged in torture or other international crimes was on notice that once out of office, they were at risk of arrest anywhere in the world on the theory of universal jurisdiction. In the end, Pinochet was allowed to leave Britain ostensibly on grounds of ill health, although this was challenged at the time, and in my book I think I've shown conclusively that there was a deal between Britain and Chile to allow him back. And upon his return, and this was consequent to the deal between the two countries, he was stripped of all immunities by the Supreme Court of Chile. He was indicted on multiple charges, and at the time of his death, awaiting trial, he was under house arrest. So this is not a case of complete immunity by any stretch. The Pinochet precedent, although not without its critics, has taken hold. In 2011, for example, former President George W. Bush cancelled a visit to Switzerland after Amnesty International filed a legal complaint concerning the Bush administration's use of waterboarding, widely recognized as a form of torture. And the Pinochet president has been the basis very recently for a French court's ruling that Syria's ex-president Bashar al-Assad could be indicted in France for his presidential role in authorizing torture on a massive scale. Although the French court in its decision threw out existing charges against Assad, and that part of the decision got the headlines, it did so only because those indictments had been handed down whilst he was still in office. Now that he's out of office, the court ruled in Paris, new indictments could be drawn up. This is the context to consider the case that former, as he was at the time, President Trump brought to the US Supreme Court in 2024, Trump versus the United States. The federal grand jury that indicted him on various counts of conspiring to overturn the 2020 presidential election result was not about international crimes. That's an important distinction. But I watched the case closely because the issue of immunity was at the heart of the case. In particular, I wondered, as the case was argued, whether the Supreme Court would follow the line taken by Robert Jackson 80 years earlier at Nuremberg and offer any sort of a carve-out for international crimes, or would it instead give a former US president some sort of immunity even for international crimes, either explicitly or by necessary inference? The lower courts rejected former President Trump's argument for a blanket immunity, or any immunity. As they saw it, he had no criminal immunity as a former president for any act he did, whether private or official. Though unstated, the lower court rulings made it clear by extension that a former US president who commits torture or genocide or disappears people or crimes against humanity in a manner that constitutes an international crime will have no immunity. Trump appealed to the Supreme Court, and that court, in Trump versus the United States, overturned the lower courts. The Supreme Court had never previously addressed a former president's immunity from criminal suit. Back in the Nixon era, it had ruled on a former president's immunity from civil suit. But the absence of a case meant there was no precedent on which to rely. And as with the Pinochet case, all 9 justices agreed there's no immunity for private acts. Like everyone else, the president is subject to prosecution in his unofficial capacity, wrote Chief Justice John Roberts. But for all official conduct, by 6-3, the justices concluded that the president was, unlike anyone else, protected by a general principle of immunity. This was because, in the view of the majority, the case had profound consequences for the separation of powers. Article 2 of the Constitution had to be interpreted to protect the president's executive powers from the risk that criminal law would be weaponized and used to constrain those powers. The nature of presidential power, wrote Chief Justice John Roberts, requires some immunity for criminal prosecution for official acts during tenure in office. It offered no real explanation as to why that should be. What this meant in practice was that where the president exercised core constitutional powers under Article 2 of the Constitution, and that includes powers that involve military action, foreign affairs, and anything to do with national security more generally. Think about Minneapolis right now. There will be absolute immunity after you have left office. And that extends to matters of evidence. In the view of the majority, without such an immunity, a president might be deterred by fear of criminal prosecution from taking, as John Roberts wrote, bold and unhesitating action which the public interest requires. Even if, in the exercise of these powers, he commits genocide, or disappears people, or commits torture, the majority seemed to be saying, as official conduct, as a former president, he will be immune from the jurisdiction of the US criminal courts. That is an incredibly far-reaching judgment, and it is totally at odds with the position taken by the House of Lords, our Supreme Court, in Pinochet. The majority adopted a slightly different stance in relation to official conduct that lies outside core constitutional powers, and for this, there would be a presumption of immunity that would only be displaced if it could be shown that it would not interfere with the exercise of executive office. Now, it may well be, I want to be careful here, that if a president of the United States were ever to be charged with international crimes, and I just mention here the Duterte case, where the killing of 41 narco-traffickers by execution has been characterized as a crime against humanity, and raised the question, is that any different from the targeting of boats in the Caribbean and the Pacific Ocean with alleged narco-traffickers on board? Raises the question of whether the court would find that such conduct falls outside core constitutional powers, so that the president doesn't have absolute immunity. But even on this, the 3 dissenting justices pointed out it's pretty hard to imagine a prosecution for official acts that pose no dangers of intrusion on presidential authority. Chief Justice Roberts simply brushed away the concern. The limitation was needed, he wrote, to avoid prosecutions of ex-presidents from becoming routine. He offered no evidence whatsoever of any past practice that supports the existence of such a risk. The Supreme Court remanded the facts of the case back to the district court, and it is there that it would have been heard, except that President Trump was re-elected and now has, whilst he is in office, complete immunity. Generally, the ruling hasn't been well received. It's had many harsh critics. Jack Goldsmith, for example, who headed the US Department of Justice's Office of Legal Counsel during the Bush administration, thought the immunity ruling was a mess, that it had a made-up feel, and that it goes much too far, creating an entirely new law that is replete with ambiguities. And he's not alone in this critique. I went up to Edinburgh to speak with Lord Hope, who'd been part of the Pinochet proceedings. And amongst other things, he said of the case, the idea that immunity is needed to allow a US president to take necessary decisions is, I use his words, absolutely ridiculous. He acknowledged that the court had not explicitly addressed the issue of immunity for international crimes, but noted that any uncertainty in this regard was in itself damaging. The ruling left in him, as he said to me, a lingering doubt and a worry that if pressed, the majority would say that its judgment applied to everything, even international crimes. The follow-on consequences of the recent Supreme Court ruling outside the US and for international law are not hard to imagine. I think we're seeing the consequences in the US today. For one thing, even without mentioning international law, the decision moves American domestic law on immunity in the direction of that taken by very authoritarian states. The majority judgment leaves a serious question mark when it comes to taking action against international crimes. It's going to make prosecutors hesitate about bringing charges, and it sort of serves to encourage copycat rulings by the courts of other countries. And of course, the judgment will short-circuit future American attempts to hold other former leaders to account for international crimes. There's also the issue of double standard. President Trump has absolute immunity. What about former President Maduro of Venezuela, who's being charged before the national courts of the United States? Lord Hope referred to the foggy nature of the ruling in concluding that it would make it difficult or impossible for the United States to argue against immunity for former leaders charged with international crimes and facing proceedings before national or international courts. If a former US president might have immunity for everything, as the current president would undoubtedly argue, then why shouldn't Milosevic or al-Bashir or Assad or Duterte or anybody else? A former head of state of another country who turns up in the US and is charged with an international crime will be able to assert that they should have no less immunity than that accorded to a former US president. The highest courts in other countries, countries like Germany and Argentina, that until now have not allowed far-reaching immunities for their own former heads of state, might now be encouraged to follow suit and follow what the United States has done. If the highest American court is receptive to immunity for a former president with respect to international crimes, as this judgment suggests, and as Russian law already mandates, then why aren't the courts of other countries going to follow suit? The uncertainties generated by this ruling undermine the values that have been advocated by the United States since 1945, including by Republican administrations. The approach and tone adopted by the words of the Chief Justice in the 2024 Supreme Court ruling invite us to imagine how different things would have been if he had been at Nuremberg in 1945, and the very different kind of letter he would have written to President Truman if it had been him, John Roberts, rather than Robert Jackson, who'd been invited to draft the charter of the Nuremberg Tribunal back in 1945. The reason I've focused on this issue of immunity is because it juxtaposes the House of Lords judgment of March 1999, which in effect follows the approach articulated by Justice Robert Jackson in June 1945 in his letter to Harry Truman, on the one hand, and the Supreme Court judgment of July 2024. They offer a point of comparison. The recent judgment of the Supreme Court can be seen to reflect a broader change that is taking place, one that may affect all of us in relation to the place and role of law in matters international, a desire to limit the constraints placed by international law on executive action in the domestic sphere and on the actions of states in international matters. And that's why this is relevant to the current conversation, very much in the air, that we are living through a moment of great change to a world that is without law. On the 12th of September 2025, the Financial Times published an editorial which it headlined, "A World Without Rules." The headline came with no question mark. That newspaper's view was premised on two recent events that occurred within 24 hours of each other. Israel's launch of a missile strike on a building that housed Hamas officials in Qatar, described as an important non-NATO ally of the United States, and the flight of 19 Russian drones into Polish airspace, several of which were destroyed by Polish and NATO aircraft. These incidents, the FT editors noted, highlighted what they called the accelerating US retreat under Donald Trump from its global policeman role and the creation of a no-rules world, one that marked a shift from a rules-based order to one based on transactions and unilateral force. This, the FT worried, was producing a kind of anarchy and a proliferation of violence. A few days after that article appeared, White House Deputy Chief of Staff Stephen Miller declared, and I quote, "We live in a world that is governed by strength, that is governed by force, that is governed by power." And he swatted away all the concerns of legality about the abduction of Nicolas Maduro and violations of Venezuelan independence and territorial sovereignty. These are just legal niceties, he said. And President Trump then followed him and simply said, "I don't need international law." The FT is certainly not alone in identifying a fundamental change or expressing concern as to where we are headed. Others have adopted what appears to be a more sanguine or accepting view. I'm thinking here of an article that was published a year ago, just before Mr. Trump took office for the second time, by Professor John Bew, an article that was published in the New Statesman. He is Professor of History and Foreign Policy at King's College London, and he was a foreign policy advisor at 10 Downing Street, initially appointed by Boris Johnson. He's a scholar I admire very much, not least the author of a really very fine biography of Clement Attlee, British Prime Minister from July 1945 until October 1951, a true champion of a multilateral world. In the New Statesman article, Professor Bew addresses the rules-based system, as he called it, and challenges the attitude of those who advocated its continuing role. And he focused on me, someone who he said was imbued with a sentimental view. And it is certainly true that I am, on occasion, a very sentimental person. Unlike my wife, I cry during films, or if I'm at the Matthew Passion. If I think of Hirsch Lauterpacht, who I wrote about in East West Street, finding solace by listening to Bach while preparing for the arguments of the Nuremberg trial. So, frankly, I've got no problem at all with being accused of sentimentality. But those who know me well know that when it comes to matters of law and the world, I'm as hard-headed and realist as anyone else. As I put it to the judges of the International Court of Justice in February 2024, in the advisory opinion hearings on the legal consequences arising from policies and practices of Israel in the occupied Palestinian territory, I said, no one in this great hall of justice is starry-eyed about international law. But it's what we have, and it's what the role of the court of the judges is, to affirm the place and power of international law. And in that case, I argued, that included the obligation that Palestine met the criteria of statehood under international law, and this was a thing the court subsequently did. Professor Bew believes that Britain's historic support for the rules-based system is motivated by self-interest. I have no problem with that. Britain has been a champion of a rules-based international system, he explains, in part because this system was built in our own image, designed to benefit our commercial and diplomatic interests, and much enforced by our closest ally, the United States. But he now believes Britain, and no doubt many other countries too, should not bet on a retrospective sentimentality of respect for that system. Much as we may wish it to be the case, he writes, we're not in a rule of law era today. No, he continues. In his view, raw power is being asserted everywhere we look. And those who operate on the global stage are willfully flouting the rules of the post-1945 legal international order. And he references Russia's February 2022 invasion of Ukraine, a flagrant violation of the fundamental principles of the UN Charter as it's possible to imagine, he calls it, and contrasts what he calls Britain's negligible and comparatively minor historical transgressions. Those are his words. He passes in total silence on Britain's role in the occupation of Iraq back in 2003, which many, including myself, consider to be manifestly illegal, and the justifications for which, no weapons of mass destruction in our neighborhood, were of course seized upon by President Putin to justify the occupation of Ukraine. No, Bew argues, today is different. Today is all about raw power, which is coupled with technological changes and the arrival of artificial intelligence, which has its own rules-based system, which will ultimately, in his view, consign us, humans, and our rules to a lower tier. In this era of raw power, he writes, fortune favors the brave. It's an era in which muscles will be flexed, and whilst recognizing that some deals may also be made, he calls for a statecraft that goes beyond the maintenance of a rules-based international system. He writes, we have to be able to walk and chew gum with a bit of spaghetti Western swagger, not fester in the sentimental education or nobility of a rules-based system, a world view of rules. Well, that is certainly one view, and it's shared by others. Have a look at the latest edition of The Spectator, which has a cover portraying 4 individuals who it believes to be the guilty men for believing in a rules-based system. Is it the case, however, as John Bew puts it, that raw power is being asserted everywhere we look? I wonder. I'm going to make 6 points in relation to that issue. First, there's nothing new about raw power today. The assault on international rules has been more or less continuous in one form or another since 1945. Long before Ukraine or Qatar or drones over Poland, there was Hungary, Czechoslovakia, Vietnam, Laos, Cambodia, Afghanistan, the DRC, Iraq, Palestine, Israel. We've known a multitude of acts of manifest lawlessness and moments of acute lawlessness. That's why I published a book in 2005 with the title Lawless World, but not a world without law. Second, it's undoubtedly the case that there is a rampant lawlessness today, at least in respect of certain rules of international law. I'm thinking of the rules governing the use of force and the rules of international humanitarian law. Given what's happening in Ukraine and in Israel-Palestine and in Sudan and in so many other places, it's hard to disagree with the point made by Yale professor Una Hathaway, writing in The Guardian, that the protection of civilians under international humanitarian law is being eroded, in her words, to the point of threatening to lose all meaning. And the same may be said of the terrorist policy of the current US administration, which manifestly violates the rules of the World Trade Organization, not least the most favored nation principle that is the beating heart of that multilateral system, and requires trading partners not to act in a discriminatory or arbitrary manner. And the same might be said of China's refusal to give effect to the rulings of the Annex 7 Arbitral Tribunal in the dispute with the Philippines, in which I was counsel for the Philippines, on the South China Sea. Third, a lawless world is not a world without law, or a post-rules world. The fact that certain laws are being violated does not, as such, mean that they cease to exist. As far as I'm aware, the rules governing the prohibition on the use of force, Articles 2.4 and 51 of the UN Charter, did not disappear with the invasions of Iraq and Ukraine. The rules set forth in the 1949 Geneva Conventions and their 1977 protocols on the protection of civilians in times of armed conflict did not cease to have their writ in the face of attacks on civilians in Ukraine, in Israel on October the 7th, or in Gaza subsequently, or in many parts of Sudan. These rules continue to be in force, to exist and to be in force, and they are relied upon to generate responses, including political responses, and in some cases, they are invoked to hold violators to account at a much later stage. And that is not nothing or meaningless or without consequence, as Senator Pinochet found out to his cost. To take but one example, the United States is currently using military force to destroy boats and human beings said to be involved in narco-trafficking in the Caribbean Sea and off the Pacific coast. On its face, and according to the material that's in the public domain, and I'm not privy to anything else, that policy and practice appears to be in manifest violation of the rules governing the use of force, and it has produced consequences. The media has reported that the United Kingdom and France are no longer sharing intelligence with the US about suspected drug trafficking vessels in the Caribbean because they don't want to be complicit in US military strikes and attacks that are manifestly illegal. Admiral Alvin Halsey, the commander of US Southern Command, has left his post just a year into tenure, reportedly after raising questions about the legality under international law of strikes that have reportedly now killed more than 100 individuals. Fourth, while some rules are undoubtedly being flaunted, and gravely so, the fact is that the vast majority of rules of international law continue to be respected and to operate and apply in a manner that's fully effective. When I go from London to Paris and back, my trip is made possible by the operation of a dozen or more international treaties. So are my flights to or from Colombia, where I was earlier this week, or when I leave next for the United States. So are the phone calls I make on my mobile phone, and the purchases I make on the internet, and the foods I eat, and the medications I take, and the air I breathe, and the music I listen to, and the films I watch. All of these, without exception, are based on an international rules-based system, treaties which allow us to do all of these things, whether it's intellectual property rights or double taxation or other sets of issues. I could go on. Every aspect of my life, every aspect of your lives are informed by the effectiveness of international treaties and other international laws. They operate behind the scenes. They're unseen, they're silent, they're seamless, and they're completely effective. Is this raw power? Is this a post-rules world? Is this a world without law? No, it is not. The American oil companies will not invest in Venezuela because under international law, where duress is exercised, there will be a serious question of title over that oil. You need a rules-based system even to make those kinds of things happen. My fifth point, in a post-rules world, you'd expect international lawmaking to have ground to a total halt. Has that happened? No, it has not. The examples abound, and not just in the technical field. This month, states held the first ever negotiations at the UN to create a new UN Convention on the Prevention and Punishment of Crimes Against Humanity to fill the gaps that exist alongside the 1948 Convention on Genocide. That was over the heads of objections from Russia and China and the silence of the United States. It exemplifies the kind of approach that was articulated by Canadian Prime Minister Mark Carney when he said, in the face of what is going on, other states have to pick up and run with a rules-based system. And that is happening. States have adopted, within the past few months, under the auspices of the Council of Europe, a new treaty to create the first international tribunal on the crime of aggression since Nuremberg in relation to Russia's illegal occupation of Ukraine. That was announced in May 2025 by the foreign ministers of 40 countries who met in Lviv to honor the work of 8 decades ago of the 2 former residents of that city who are the main stars of my book East West Street, Hersch Lauterpacht and Raphael Lemkin, who gave the world the legal concepts of crimes against humanity and genocide. Since 2022, 19 new bilateral investment treaties have come into force. 2 years ago, in June 2023, 145 states signed the agreement under the Convention on the Law of the Sea on biological diversity. The third implementing agreement, as this is to the UN Convention on the Law of the Sea, has already been ratified within 2 years by 75 states, and it entered into force 2 weeks ago, less than 3 years after it was signed. By comparison, UNCLOS, signed in 1982, took 22 years to come into force. Is that a post-rules world? I don't think so. And that brings me to a sixth point. In a post-rules world, you might expect international courts and tribunals to be in a state of collapse or disappearance. It's certainly the case that some tribunals have disappeared. The Yugoslav and Rwanda tribunals, for example, have completed their work. And the investor-state arbitration provisions under the North America Free Trade Agreement have not been taken through in the successor treaty. But the numbers of treaties stopping to have access to international courts and tribunals is very, very limited. The Conservative Party in this country would like the United Kingdom to join Russia and Belarus and leave the European Court of Human Rights. That really is one of the saddest things imaginable. If you go back to 1948 and 1949 and 1950, when that convention was negotiated, it was led by British lawyers, including British conservative lawyers, precisely because it took the fundamental principles of the common law, articulated them in treaty form, and sought to have them applied internationally. There are literally no cases against the United Kingdom before the European Court of Human Rights. 1 or 2 judgments against the UK at most. What on earth is going on that a reasonable political party would call for the United Kingdom to leave such a treaty? What signal does that send to the rest of the world? And the ECHR isn't about to disappear. It is being strengthened, it's being refinanced, it is carrying on with its work, as some of you in this room will know. The same may be said of the International Criminal Court, which faces a myriad of challenges, not least sanctions from the United States against serving judges and prosecutors simply for doing their work. But this has fortified the commitment of other states to support the ICC, and it has fortified, under very difficult conditions, the extraordinary people who work in these courts. Have they disappeared? No, they haven't. Will they disappear? I don't think so. Many of the courts and tribunals that I work at are busier than ever. When I learnt my international law at university in the 1980s, the Permanent Court of Arbitration had no cases at all. Today, in 2026, it has hundreds of interstate cases and investor-state cases. Its neighbour in The Hague, at the Peace Palace, is no less busy. The International Court of Justice currently has 23 contentious cases on its docket. That is more than at any time in its 80-year history. The court's advisory function has attracted unprecedented engagement in recent years. 37 countries participated in the advisory opinion proceedings on Chagos, which led to the historic February 2019 advisory opinion. As you know, as a consequence of that decision of the International Court of Justice, in November 2022, Mauritius and the United Kingdom opened negotiations on a treaty to give effect to the opinion. And 3 years later, in May 2025, the treaty was signed, recognizing Mauritian sovereignty over Chagos, allowing the military base at Diego Garcia to continue, and providing for the conservation of a remarkable marine environment. It also does something else that is absolutely remarkable. It will allow the Chagossians who wish to do so to return from their forced deportation to any of the islands except for Diego Garcia. President Trump signed off on that agreement in May 2025. It's been in the news again. The media is reporting today that once again, President Trump has given it the thumbs up. I'm going to give credit to a strange person for that treaty. I have watched with astonishment as one conservative politician after the other attacks the treaty, apparently having forgotten that in September 2022, it was Prime Minister Liz Truss who opened the negotiations for the treaty. And I was part of the negotiating team for Mauritius that then negotiated for the next 2 years with successive British foreign secretaries, James Cleverly and Lord Cameron, and Deputy Prime Minister Oliver Dowden, a treaty that, to all intents and purposes, is exactly the same as the treaty which a Labour government finally brought home just a few months after it came to power. A post-rules world? I don't think so. So what is actually happening? I do not ignore, and I'm not starry-eyed about the assault on some parts of international law that is underway from some quarters. But the greater truth, I suspect, is reflected in a wonderful book written by the Italian writer Giuliano de Empoli, and I really commend you to reading it. It's called The Hour of the Predator, and it assesses the double impact of the new populist class of political predators and what he calls the digital conquistadors, the tech moguls. What these two communities have in common, writes da Empoli, is both an enemy and a strategy. Kill all the lawyers. In drawing on Shakespeare, or maybe Dick the Butcher in Henry VI, da Empoli concludes that working together, the political predators and the tech moguls have decided to wipe out the old elites and their rules. And the principal targets are the lawyers because, as he writes, they are the henchmen of power, devoid of morals and ready to support anything and everything. Lawyers do not solve problems, in their view, he writes, they create them. They always have a loophole at hand to further complicate matters. They're interested in form, not substance, and they speak an incomprehensible language for the sole purpose of deceiving the poor and uninstructed. In the end, da Empoli writes about the views of these two casts of characters. They care only about their own business, and they are the targets of the populists, and they are the targets of the tech moguls. And it's not just the lawyers who are the targets, he says. It's also their rules and institutions, their courts and their judges. The ideas aired in the 1941 Atlantic Charter and the 1945 settlement that followed, with its commitment to rules on free trade, on the rights of individuals and groups, and on the prohibition of the use of force. Da Empoli offers a clear warning. If the political predators and the tech moguls, and I quote him, succeed in achieving this goal, it will not only be the parties of lawyers and technocrats that will be swept away, but also liberal democracy as we have known it until today. And that's the challenge that he identifies. There's an overlap here with the ideas of Professor Bew, which you will surely have noted. He embraces this change, and he invites us to be less sentimental and to accept it, to chew gum and eat the spaghetti of the world as he sees it. And that's where John Bew and I part ways. I don't take it as a given that that is where we are heading, and that henceforth these are the sunny uplands to which we must draw. We've been here before. Is there really anything that's so new? As a schoolboy, I read and now remember George Orwell on the subject of weapons, although he might as well have been talking about technologies or access to the printed word. Though I have no doubt exceptions can be brought forward, he wrote, I think the following rule would be found generally true, that ages in which the dominant weapon is expensive or difficult to make will tend to be ages of despotism, whereas when the dominant weapon is cheap and simple, the common people have a chance. A complex weapon makes the strong stronger, while a simple weapon, so long as there is no answer to it, gives claws to the weak. As an adult, many years later, I read, and now bring to your attention, a remarkable novel by Eric Vuillard called The Order of the Day. It won the Prix Goncourt in France in 2017. And the book opens with a remarkable account of the meeting on the 20th of February 1933 between the recently appointed president of the Reichstag and the Chancellor of the Reich and Germany's 24 top industrialists. He writes, they are called BASF, Bayer, Agfa, Opel, IG Farben, Siemens, Allianz, Telefunken. By these names, writes Vuillard, we shall know them. In fact, we know them very well. They are here beside us, among us. They are our cars, our washing machines, our household appliances. They are here, there, and everywhere in all sorts of guises. Our daily life is theirs. And the 24 gentlemen of the palace of the president of the Reichstag on that day, the 20th of February, are none other than the clergy of major industry. And there they stand, effectless, like 24 calculating machines at the gates of hell. Hermann Goering goes around the table with a word for each and seizes each industrialist by the hand. He mumbles a few words. The 24 sphinxes listen closely. Time to get rid of that wishy-washy regime once and for all, Goering tells them. The 24 industrialists nod solemnly. Hjalmar Schacht rises to his feet, smiles at the assembly, and calls out, "Now it's time to pay, gentlemen." To anyone who watched the inauguration of President Trump and the tech moguls there assembled, this will all seem incredibly familiar. To those who've paid attention to the large US law firms or to some universities cutting deals with the new administration, this will look incredibly familiar. 12 years later, Goering and Schacht were in the dock at Nuremberg. Plus ça change, plus c'est la même chose. Not long after, in 1936, Hans Frank, who had served as Hitler's lawyer for 5 years, from 1928 to 1933, and who I write about in East West Street, and now presided over the annual Congress of the Deutsches Akademie für Recht, dismissed the idea of an international criminal tribunal. It was proposed during the Congress that Frank presided over by a French professor of criminal law, Professor Henri Donnedieu de Vabre. It is ridiculous, your idea, Frank tells the French professor and all the gathered academics. Just 10 years later, on November the 20th, 1945, Hans Frank entered courtroom 600 as defendant number 7 in the famous Nuremberg trial. One of the judges who entered the room a few minutes later and would convict him the following year and sentence him to death was Judge Henri Donnedieu de Vabre. So it seems tempting today to cast aside the 1945 settlement. That's in effect what Professor Bew proposes. It's a position that President Trump's administration appears to embrace. A bit of swagger, and you can boycott COP30 on climate change, or for a year or maybe longer, the adoption by the International Maritime Organization of new international rules on carbon dioxide from ships, or you can embark on a policy of mass killing of alleged narco-traffickers in the Caribbean Sea. But these are not policies that are sustainable over the longer term. They produce reactions from others. I've already mentioned the UK's response in relation to the Caribbean killings. We have observed with concern the military operations in the Caribbean region because they violate international law, said the French foreign minister. No, I don't think we are in a world without law or in a post-rules world. We are, however, in a world in which some would like to strip back or do away with those international rules, or some of them. And that is the struggle which is now underway. And I have no doubt that this is a difficult moment, and it's one in which acute expressions of lawlessness are undoubtedly on the rise, and in which some would prefer raw power to prevail, whether it's on tariffs and trade, on the acquisition of territory, or the targeting of civilians in times of conflict. And no doubt it may yet get even worse before it gets better. But history shows a pattern over the centuries. The elaboration of international rules and institutions and courts is followed by their partial destruction, and that's then followed by a reconstruction. And the reconstruction always builds on what came before. And so it will be once more, as some seek to replace multilateral agreements on human rights or other issues with a bilateral show of political or economic force or even military force. Which brings us right back to the issue of immunity with which I began this lecture. The two judgments that I've referred to, 1999 Pinochet, 2024 Supreme Court, give you a point of reference across the worlds of 1812, 1919, 1945, 1998. There was a rule of international law, even in 1812. It evolved over time and place, and no doubt it will continue to do so, as will other rules of international law, as values and priorities change, as power shifts. Imagine the kind of letter that John Roberts would have written to President Truman if he had been the Chief Justice at Nuremberg in 1945. And I make up the following quote. We've decided to maintain the idea of immunity for former leaders, to ensure that they're not enfeebled or made overly cautious by the fear of criminal prosecution after they leave office. We've concluded that immunity is not an obsolete doctrine or a relic of the doctrine of the divine right of kings. It is a vital, necessary, and living thing. It is fully consistent with the position we take towards our own former presidents. We accept the paradox that legal responsibility should be the least where power is the greatest, including in relation to crimes under international law. Where official conduct is concerned, we accept that a president and a former president and heads of state and leaders have full immunity. Imagine those words in 1945 and how the world would have looked. These are not words to quicken our hearts. As a litigator, not so long ago, in December 2019, I sat right next to Aung San Suu Kyi, winner of the Nobel Prize, in the proceedings brought by the Gambia against Myanmar that we were discussing just before we came on stage. Allegations of violations of the 1948 Convention on the Prevention and Punishment of Genocide. Remarkably, back then, she was the agent of Myanmar. And I didn't agree with very much that she said that day. We were on opposite sides. But I find myself constantly coming back to one of the things that she did say in addressing the judges in her opening remarks as agent. She said, and I quote, "International law may well be our only global value system," end of quote. I think she was right. International law isn't about to disappear. No doubt it is far from perfect or effective, and it will be informed by expressions of raw power. But it's not about to be replaced by raw power totally. The world is simply too complex and too interdependent for that to happen. No doubt some will walk and chew gum with a bit of spaghetti Western straggle. There's nothing new in that. Hans Frank swaggered once. Augusto Pinochet swaggered once. Swaggering and gum gave us Iraq and the palaver over the Northern Ireland Brexit Protocol. And then over time, such people encounter other realities: political, diplomatic, economic, military, ecological, human, legal. And they learn that accommodations have to be made. And those accommodations lead to agreements, and those agreements are always governed by international rules in one form or another. I can put it no better than Tom Bingham writing back in 2010, and I quote, "If the daunting challenges now facing us are to be overcome, it must be an important part through the medium of rules, internationally agreed, internationally implemented, and if necessary, internationally enforced. That is what the rule of law requires in the international order." And that is, after all, how it has always been. A local lesson I learned many years ago in the mid-1980s when I was starting off my life as a very junior legal academic working under my dear friend Elie Louterpact. I came to know the professor of English legal history at Cambridge University, Sir John Baker. And occasionally he'd invite me for lunch as a young academic. That was incredibly exciting. And he'd ask, "What aspect of international law are you working on?" And I would give him a response, and he would look at me and he would reflect in his very considered way. He would stroke his little beard, and then he'd say, "Ah, yes, We had a similar problem in English law at some point around 1475. And it took 275 years to sort out. And so it is with the rules of law that straddle our globe. It's one step forward, one step sideways, one step backwards, another step forward. In the meantime, no doubt, there will be mayhem and there will be bloodshed. But it is a long game, and we'd better hunker down and get ready for it. Thank you very much.